Hello, good morning. I hope that you can hear me and see me well. I understand from my IT department that you will not be able to speak directly. However, at the bottom of your screen, you will see a section for Q&A. So if you will have any questions during the presentation, just feel free to use this button. You can also ask any unrelated questions regarding the presentation, as long as it covers the labor law. So as for the introduction, for those who don't know me yet, my name is Sabina Krejčková, and I'm the head of the labor and employment practice in Prague's Squires office in the Czech Republic. Besides the labor law, I focus also on the data protection, IP laws, and compliance. And for today, I prepared for you a short presentation regarding the update of the Labor Code, which has been recently approved by the Senate. Basically, I believe that the presentation will be definitely shorter than originally planned, 45 minutes. But let's see if you have some questions, so for how long we will be able to make it. All right, so let's start. As I already mentioned, the update was already approved last week, and it was delivered to President for his signature. And he is usually very fast with signing of new legislation, so it is expected that the Flexi update will become effective either on 1st June or on 1st July. I prepare for you for the introduction some overview of the main changes which will be discussed today. And this relates, for instance, to extension of probation periods, changes to notice periods, new deadlines for dismissal due to employee misconduct, flexible working arrangements for parents employees, health-related termination and severance entitlements, easing of certain salary administration for wages, and changes to occupational medical examinations. I would probably also add that the most discussed proposed change to be able to terminate the employment without any termination ground has not been approved. So as an employer, you will still need to have some termination ground listed under the labor code in order to terminate the employee. So let's start with the first change, and this includes probation periods. Under the current legislation, the maximum statutory limit, which you can agree the probation period for regular employees is 3 months, and 6 months for managerial employees. I'm sorry. Managerial employees is basically any employee who is authorized to instruct or manage other employees. Under the new regulation, those periods are extended to 4 months for regular employees and up to 8 months for managerial employees. However, the probation period is still kept of the half of the agreed fixed term duration. So for example, if you have a 1-year contract with managerial employee, you may still have only 6 months probation period with him. What is important to mention, it will be newly possible to extend the probation period later, as long as it is within statutory limits. This is a practice which is now fully prohibited. So, for example, if you agree on 1 month probation period with the employee, and then you would like to additionally prolong it for 2 more months, this is not possible, and probation period will end after 1 month. So this will be newly allowed. Of course, the agreement with the employee is required. I would also stress that these new rules will apply really under probation periods, which will be agreed after the flexi-update is effective. So for example, if you already have some employment contracts concluded, which will start later, let's say from September, so the old rules will still apply even to the possibility for the extension. So be aware of this, that if you would like to apply the new rules, you will need to wait until the update is effective. Then we will continue to notice periods. Currently, the statutory notice period is 2 months and begins to run on the first day of the month following the month in which the notice is delivered to the other party. This period can be extended. However, it must always be the equal for the both parties. Under the flexi-update, the calculation for the moment when the notice period starts is completely changed, and the notice period will start immediately on the day of the delivery, the notice to the other party. This means, for example, if you have a notice, if you deliver a termination notice to the employee on 8 April, the employment will end on the 8 June. Furthermore, there is a shortened notice period for employees terminated for cause. For example, poor performance, breach of employee duties, or failure to meet legal requirements for the agreed work. In such a case, there is only 1 month notice period. So if we take the same example, if you deliver the termination notice for the employee misconduct on the 8th April, then the employment will end on the 8th May. And the notice period can still be extended by agreement. Definitely, you must bear in mind that the notice periods, those new notice periods will not apply automatically. So if you already have notice periods stipulated in the employment contracts or any other agreements with the employee or internal policies, you will need to update it in order to apply the new rules. In case of employment contracts, it is of course a little bit more tricky, as you will need to have an employee's consent with such a change. So what I usually recommend is to use this update, for example, when you prepare amendments for annual increase of the salary. So you will just add also the information about the new rules for the notice periods. You should be also aware when you are terminating the employee for the misconduct, you don't have any unlimited time during which you can do it, as there are quite strict statutory deadlines in which you can dismiss the employee for the particular breach. And those deadlines are two. One is subjective period, and it starts to run from the moment when the employer learns about the breach. And the second is called the objective period, and this basically this expires within 1 year when the breach occurred. Under the current legislation, the deadline for the moment when the employer learns about the breach is 2 months, and the new legislation extends this deadline to 3 months. And with respect to objective period, the deadline will be newly 15 months. So even though it still feels quite short, the deadlines, I believe that it will definitely help. I would also add that there is quite a lot of case law related to the calculation or the moment when the subjective period starts. And under the recent court ruling, it is not sufficient only if the employer has some kind of indication that the misconduct happened, but the employer should really have credible knowledge that the employee indeed breached his or her duties and in what period. Also, bear in mind that if it is sufficient if any direct supervisor of the employee learned about this breach. In such a case, the subjective period of 2 months or newly 3 months will start to run as well. unless the misconduct is committed along also with the supervisor. As also in the previous cases, the old deadlines will still apply to the misconduct or any internal disciplinary proceedings which occur before the effective date of the flexi-update, and also the deadlines for dismissals related to a breach of sick leave regime. This means, for example, when the employee is not allowed to leave their house during their sick leave, and they will not be at home. The deadlines remain unchanged, and subjective period for the employer is 1 month, and the objective period is 1 year when the breach occurred. We will stay in the termination grounds, as further changes relates also to the termination due to health incapacity of the employee. The new legislation consolidated the employee's health incapacity under the single ground, newly Section 52 letter D of the Labour Code, and employees who are dismissed who are unfit for work due to a work accident or occupational disease will no longer be entitled to severance pay from the employer, but instead they will be eligible to a special compensation which is paid from the employer's statutory liability insurance. The amount remains unchanged. It will be still 12 monthly average salaries of the employee. However, it is considered to be a big relief for employers and for companies, as it was paid basically from their budget. So this will help them in case of those accidents. Nonetheless, if the dismissal is due to reaching the maximum exposure limits in the workplace, the severance pay is still paid by the employer, and this is the same amount as it was before. That means 12 monthly salaries. Also, I believe that everybody knows that the same compensation package or severance applies also in the case of termination by mutual agreement. If the employee is dismissed for general health incapacity not related to work accident or occupational health disease, in such a case, they are not entitled to any extra pay unless it is agreed with the employer or stipulated by the collective bargaining agreements. Now we will continue to the changes related to employees on parental leave. As under current legislation, the employees are basically forbidden during their parental leave to work for the employer to perform the same time of work. Otherwise, if they agree, for example, to shorten their working hours or to be engaged on agreement outside of employment, typically agreement to perform work or on agreement on working activity. In Czech it is dohoda o provedení práce a dohoda o pracovní činnosti. In such a case, their parental leave is terminated. They still might be entitled to parental leave allowance. However, like the statutory parental leave under the Czech Labour Code will be finished. The new regulation will introduce an exemption for employees on parental leave, and they will be now allowed to perform the same type of work on the agreement outside of employment. So this will give them flexibility to still stay on the parental leave, however, to partially work for the employer. The new legislation also protects the working employees in the respect that now currently the employers must keep the original job and workplace for employees taking care of child only until the end of the maternity or paternity leave or parental leave in the extent of maternity leave duration. However, under the flexi-update, employers must hold the same job position for employees returning from parental leave until the child turns 2. And it is also important that in this case, this rule applies retroactively. So if you have any ongoing parental leaves In such a case, you will now have obligation to keep this absolutely same job position until the kids reach the age of 2. The further change relates to some kind of lifting of rules for administration of wages. As currently, if you have any, in particular, if you are international companies, you probably know that you can agree any currency as salary. However, you must always pay out the salary in the Czech crowns, no matter what has been agreed, and the exchange rates are also stipulated by the Labour Code. The Flexi-Update will extend the list, as currently you can pay the employees in foreign currency only for employees who are working abroad. The Flexi-Update will extend the list to another group of employees who might be paid in foreign currencies, as long as the Czech National Bank basically recognize this currency. And the new list will include foreign nationals, EU citizens who do not have any permanent residency in the Czech Republic or Czech nationality, and employees who are either permanently residing abroad or who are taking care of their family members living abroad. Another change in the administration of wages allows to deliver electronically salary statements with easier rules. Just to add, salary statements are called in Czech mzdové výměry, which is basically the type of agreeing on salary which does not require an employee's consent. So it is an unilateral document issued by the employer. Currently the rules for delivering salary statements are quite strict. However, under the new legislation, you can deliver salary statements electronically without the employee's consent to any of the employee's electronic address, including company emails. So there is no exception that you need to have a private email address of the employee. And the only requirement is that the employee confirms the receipt of the salary statement within 50 days of delivery. Last change, which results from the implementation of the Equal Pay Salary Directive, is the prohibition to include confidentiality clauses about salary in employment contracts under the fine of 400,000 Czech crowns. So if you have any confidentiality clauses in the employment agreements, I definitely recommend to review it and to remove it to avoid any potential fines. Now we are continue. I believe that it was very quick to other notable changes. So the one which I found quite relevant and which also result from the European law is the entitlement of the employee to accrue annual leave during the unlawful dismissal dispute during the whole litigation period or until the moment when the employment is lawfully terminated. Furthermore, the initial medical checkups for first category of job position have been lifted. However, both parties can still request them. And also be aware that minor employees, for minors, the mandatory checkups are always obliged, are always required, even for agreements outside of employment. That means agreement to perform work or agreement on working activity. Furthermore, the daily rest, the statutory minimum limit of daily rest can now be cut to 6 hours during a 24-hour period. The current limit is 11 hours, and this applies in case of emergencies. And it cannot be used for minor employees, and the compensatory rest must be provided the following day. Additionally, there is a possibility to employ children over 14 years, even if they have not completed elementary education, during the main school holidays, with the condition that their working hours cannot exceed 35 hours per week. Furthermore, leave for impediments on the employee side, for example, medical checkups, any family events, has been extended also to registered partners, same gender couples. And trade unions must newly provide evidence that they meet the statutory requirement of at least 3 members. Before, it was absolutely impossible for employers actually to verify that trade unions have been established in the company, so this should help to employers to have any knowledge that trade unions are operating at the company, and the employer can fulfill the obligations which he will have from trade union, arising from the establishment of trade unions. All right, so this is basically everything. I prepared also some kind of summary for you to remember what I mentioned during my presentation. So be aware that certain changes of the Flexi-Update will definitely require amendments to your existing employment contracts, particularly those changes which relate to probation and notice periods. I will be very happy to assist you with this if you will need it. Also, don't forget that probation period must always be agreed in writing no later than on the date of employment commences. So, for example, if you decide that you would like to have a probation period, for example, when the employee even the first date of the employment, it will not be no longer valid, as it must be agreed on the day when the employment starts. Also, the deadlines for termination, those subjective and objective period, 3 months and 15 months. This will apply to internal investigation and disciplinary proceedings, which will occur after the effective date of the Flexi-Update. As well, the obligation to pay severance pay for occupational diseases and work accidents that occur before the effective of Flexi-Update will remain unchanged. Don't forget that you have the obligation to maintain the same job position for employees for the parental leave until their kids reach the age 2. And you can now deliver salary statements to the employee's company email, subject that the employee confirm the receipt of the salary statement within 50 days. So this is everything from my part. I don't see any questions, so we still have quite a lot of time. So if you have any questions, just really feel free to send it through the Q&A button. I hope that it works. And if you don't have any questions now, we will share the presentations with you, and you can send me the questions even after the presentation. Oh, well, Q&A works. Thank you. Okay, excellent. So thank you very much for your attention. If you have any further requests or comments, as I said, we will share the recording with you and also the presentation, and we'll stay in touch. Have a lovely day. Bye.